Hello and welcome back to the next class of Ekcel Academy. In today's session, we are going to deal with capital market and securities laws. Most of the students have this opinion that this particular subject is very boring, it is challenging, it is not interesting, or it is very difficult. But if you study this subject in the way it has to be, you know how to read a law, you know how to read a regulation, plus the most important thing, if you have the conceptual clarity, this subject is going to come across as the most interesting and easiest subject. So at Ekcel Academy, we focus on providing conceptual clarity over and above anything else, because if you have conceptual clarity, however twisted the question is, however tricky the question is, you will be able to apply the concept to the given scenario and answer that particular question. So whichever subject you're going to study, you have to focus on getting conceptual clarity, which we at Ekcel focus on. So with this basics, let's just begin the session for today, where we are going to discuss collective investment schemes. These collective investment schemes are regulated under the SEBI Collective Investment Scheme Regulations of 1999, which is going to be the topic of discussion for today's session. Why have I chosen this particular topic for discussing in today's class is, if you see the past question papers of the institute, you will see that at least questions of value close to 7 to 8 or 10 marks is asked from this particular sub-chapter. So I thought it is an important chapter that has to be discussed in today's session. So before going into the actual regulatory provisions about what is the scheme, who regulates the scheme, how it is regulated, what are the activities, before going into those aspects, let's briefly understand in a regular given scenario of what is a collective investment scheme. Let's assume that there are a set of 5 friends. All these 5 friends are planning to take a trip abroad, and they require a lot of money to travel abroad or take a trip abroad. So they thought that let us collect certain sum of money, and that money we are going to invest, and whatever money is going to be accumulated through the investment, that money put together, we are going to take this particular trip. We are going to go abroad. So what is the objective here? Every friend is going to contribute certain sum of money. That money they are going to keep it in some bank, or further they are going to invest it somewhere, and ultimately the principal amount plus the investment income, whatever they are going to get, the collective money that is there, that is going to be used for their ultimate objective, that is to take a trip abroad with all their friends. So this is the objective. This is a collective investment scheme where collectively a lot of people are putting money into some activity, into some investment, which all of them have a common objective of. Here all the friends who are planning to take the trip, who are going to be a part of the trip, who want to travel abroad, all of them are collectively giving certain sum of money. They are investing it, and the money that they have given plus that money which they have given, they are going to invest it somewhere else. So you are going to get income from that investment. Collectively the principal amount plus the investment amount together, they are going to have a lump sum money. With that amount they are going to spend on the trip that they are going to take. So this is in simple terms a collective investment scheme, the purpose of which is to travel abroad. Now if all the friends have a common objective, all of them are genuinely wanting to do this, it is a valid collective investment scheme, and ultimately all of them are going to go on a trip. There is nothing wrong in this. Imagine a scenario, same given situation, that there are 5 friends, out of which one friend, he has conceived this idea. He is saying to all his friends that let's take a plan, let's make a plan, we're going to go abroad, we are going to travel, so let's start collecting the sum of money. All of us are going to contribute so that we can take this particular trip. All the other friends are excited, but they don't know about his ulterior motive. He knows that his parents are going to shift, he is no longer going to be in the same city, he is going to move another country itself. So what he is doing, he is planning a scam. He is saying that let me take a lump sum money from all my friends by giving them an impression that we are going to plan a trip. When all the people are going to contribute their money, he is going to take that money and escape, because anyways the entire family is going to shift from India to some other country. Who is going to catch him? Where will the money go? Right? So here his objective of collecting the money from other friends by proposing this particular plan or proposing this particular trip is having some wrongful motive. What does he want to do? He wants to take that money and run away. He want to escape. He want to make some money out of the money of others without giving them the return, without returning them to the principal amount. So there are various aspects involved when we are collecting a sum of money. So where you are collecting it for a good purpose, ultimately there also you should see who is going to manage the money, who is going to ensure where we are going to invest that money further, who is going to analyze whether proper returns are being invested or not, how we should spend that money. Okay, for that also you need a person, for that you need regulations. On the other hand, where you have such wrongful activities, how do we prevent certain scams taking place? Here there is a group of 5 friends, small number of people who are going to lose their money. When we are going to launch a collective investment scheme at a larger level, where the public at large is going to subscribe to such schemes or are going to become a part of such investments, money of lakhs and crores of people is going to be lost, which is not a good thing for the country at large. So for that, we have to prevent such wrongful schemes from being launched. And that is when the government realized that there are n number of schemes which are being launched in different parts of the country, which do not come under the regulatory ambit of any of the regulators. And that is why they thought that we have to launch this particular SEBI Collective Investment Scheme Regulations of 1999. For that, we have to briefly understand the historical background of how this particular schemes were created, what were the drawbacks, what were the advantages, and why there was a need for bringing into existence this mere regulations of 1999. So let's begin by understanding the evolution. Why was there a need to bring in an exclusive collective investment scheme regulations? So what happened, like I told you, friends planned a trip, they created a scheme. Okay, this is for a smaller group of people. Similarly, like that, in the actual market, a lot of schemes were being launched for the public at large, which were not regulated by any of the regulatory authority, being IRDAI, RBI, SEBI or any PF, anything. They were not regulated under any of the regulatory authorities. So such schemes were planned, and a lot of schemes by private entrepreneurs were launched. Primarily when it started with plantation activities on commercial scale. What does that mean? It means they are going to grow some kind of commercial crop like coffee, tea, teak wood, okay, sandalwood, anything that has a huge commercial value, any crop that is commercial in nature, which is going to give you a lot of returns. One, it is going to be, when the season comes, it is going to be served. That point in time, it is going to fetch you a lot of value. On those aspects, they started creating a scheme saying that I am going to plant so and so seeds, I am going to plant so and so sapling, I am going to plant so and so trees. And generally the cropping season is long, 1 year. Sometimes it is years together if it is some kind of teak, sandalwood. So it takes a long duration. The number of days or years that are required is longer. So what they say that you give us money, we are going to buy the land, we are going to invest in cropping, and once the ultimate season comes, when we are going to actually sell the crop, we are going to share our profits with you. You're definitely going to earn a lot of returns. When you're giving us 10 rupees, we can give you 1000 rupees for the money that you have given. Such kind of ideas were brought in, and a lot of schemes were launched where they said that private entrepreneurs who had lands or who were having the capacity of having lands, they took money from the investors, invested that for crops, and promised them the returns when the crop was ready. That kind of scheme started being launched in India. What was the benefit of this scheme? A lot of plantation activity was started, a lot of cropping started, which also benefited the country. You can export the crops, plus the forest base is going to be there, erosion of forest is not going to take place. Ultimately, more greenery is going to come into picture. You're going to conserve the lands that are fit or suitable for plantation, for agriculture. So that was a positive aspect, which the government also was happy about such kind of schemes, where they said that, okay, somewhere the scheme can be of use even for the government. But nobody knew what are the drawbacks or what are the disadvantages associated with the schemes. What are the things or the areas of concerns that we had to keep in mind is that the promoters, the people who launched this particular scheme had only minimal amount of their investment. Means, if I'm going to start a company, majority of the investment is going to be mine, and the sum of money I'm going to take from other investors or take a loan from a bank, etc. I'm not going to start my business primarily on money of somebody else. That is not possible. So here what they used to do, they were the launchers, they were promoters of the scheme. They launched the scheme, but the money that they have invested is almost negligible. That means if any loss occurs in the scheme, there is a flood, there is heavy rainfall because of which the crop is damaged, anything might happen. In that case, all the loss that had to be suffered would become of the investors, and hardly it would impact the promoters. So ultimately, promoters are not at any kind of risk. All the risk is of the investors, and that is one area of concern that was identified by the regulatory authorities, that majority, that the investment that is going to be received in this particular scheme, the promoters had only minimal amount of investment in those schemes, and majority of the amount was sourced from ordinary investors, and most of these schemes were promoted in the rural areas, which helped them raise a lot of funds. Growth of the scheme. One scheme succeeded. It was a genuine scheme. That person made a lot of money. He gave good returns also. Once one particular scheme or one particular business flourishes, seeing that other people also start the same business. Now, few years back, baking, okay, all this was not very common. You had one bakery, two bakeries somewhere where you used to get cakes. Now, after COVID, everybody has started baking. Everybody has started baking. They have started their own factories. Everybody has become a home baker. Everybody is going to give some kind of facility of some kind of items, edible items to you. So that seeing one person flourish, other people also want to start doing the same thing. Same thing happened with this particular industry, where they promised high returns. One scheme succeeded, n number of other industries started mushrooming. Okay, what is mushrooming? If one mushroom is there, other mushrooms will automatically grow in. Same thing happened. One particular scheme succeeded, n number of other people started mushrooming the same scheme in the country. But there were certain things that we have to keep in mind. Is they had promised high rate of returns. That was an area of concern. It was questionable about how you are promising so much high returns. How is it possible to give such high returns? And most importantly, they marketed these kind of schemes in the rural area. Why? Because people there are not going to question much. If you're going to show them one kind of picture, they're going to believe you and they're going to make the investment. And that is why they were able to mobilize a large amount of money over a significant period of time. So most importantly, these kind of schemes flourished in the rural areas, where they were able to collect a lot of money by promising high returns. And because one scheme flourished, two schemes flourished, a lot of such schemes started coming into existence. One person might be genuine, but every person who comes into the business is not genuine. So if you have 10 players who are honest, there will be one player who is dishonest, who is not accurate, who is not doing the things according to the provisions of law. So when you have one player, no problem. When you have thousands and lakhs of schemes coming into existence, regulating such schemes also becomes very important. Now, why is there a need for regulating the scheme? First and foremost, there was a lot of complexity in the financial markets that was involved, and such unraveled financial schemes defrauded the investors by promising exorbitantly high returns and their principal investment. So like I told you, one player, two player, three players are honest, but not everybody is honest. So out of 100 people, there might be 2 people who are scamsters. There are 2 people who are going to do some kind of fraudulent activities, who are undertaking some kind of scam, because of which a lot of investors started losing their money. They promised high rate of returns, so they gave their money. Ultimately, they didn't even get their principal amount because it was some kind of scam. People vanished after taking the money of the investors. And that is when a lot of complaints started coming that we are losing money, this is the scheme, this is what happened. But there was no regulator, there was nobody who's regulating these industry or this particular kind of schemes. And that is when first time there was a need that was felt that we have to regulate these kind of schemes. In response to these Ponzi schemes, what are Ponzi schemes? Ponzi schemes are the schemes which offer you high returns on your principal amount, excessively over and above other kinds of investment. What other schemes are providing, or in other scopes of market we are going to make an investment, what returns they are promising, over and above that excessive rates of returns are promised under these particular schemes. And how do they operate? Okay, they've launched one scheme, they've done collection 1. So there are multiple investors here. You have given them some kind of maturity period, but you do not have the maturity amount, you do not have the money to pay to them. In that particular case, what are we going to do? We are going to launch one more, we are going to raise a second round of money, second round of investment, and we are going to collect the money from them. Whatever money we have collected from second round of money, that we are going to use to pay the first round of investment that we have raised. You have paid them off, they are clear. Now you have to pay the second group of people from whom you have raised the investment. For that, what you are going to do, third round you are going to raise. You are going to collect the money from them and you are going to pay it to the second round of investment. So here you are only circulating the money. You are raising more funds of money for the purpose of paying off the earlier investor. Now you have to pay the second investor. For them you are going to make a third round of investment. The money you are going to get from the third round of investment, you are going to return to the second. 3, 4, 5, like that it is going to continue, and it is only going to be a circle where you are taking the money from someone, giving it to third person, taking it, giving it. Ultimately there is no return or money that is being made. These kind of schemes are called as Ponzi schemes, where you are raising money to pay an earlier investor. That is what is called as a Ponzi scheme. And why will people invest in these schemes? Because you are going to promise them higher rate of returns. They said, let us take a risk. They are giving us such huge returns. Let us make an investment and see. They are going to make an investment because high returns are promised. Once they make the high returns, once they make the investment in such kind of schemes, the money is only going to be circulated and the money is going to be enjoyed by the promoters or the launchers of that particular scheme. So these are called as Ponzi schemes. One direct question was asked in one of the question papers about what is a Ponzi scheme, for short note. Okay. So in response to such fraudulent activities, fraudulent schemes or Ponzi schemes, SEBI formulated regulations encompassing collective investment schemes that specifically characterized a unique manner of financial manipulation. So that is when these Ponzi schemes were brought under the ambit of SEBI. Now, the government, after having a detailed discussion with various regulatory bodies, decided that it is good for us to bring a regulatory framework for regulating these kind of entities which are launching the schemes like agro bonds, plantation bonds, or any other schemes where they are taking money from the public at large, investing in any kind of activity and promising higher rate of returns. They thought that we have to bring it under regulatory ambit, and they thought who should be the regulatory authority. They thought that SEBI will be the appropriate authority for regulating such kind of schemes. But if you see SEBI regulations or the power of SEBI, they have the power to deal with only listed companies as such, where you're going to collect a lot of money from the public at large for the purpose of shares or any kind of listed security. Anything that comes under the ambit of the definition security, for that they had the regulatory aspect, they had the power. So where are you going to put these kind of schemes? Because there is nothing involved, there is no company as such, it's not a listed company, you're not dealing with the securities of a company. Here is plantation, holiday plans, such kind of plans are there. So why will SEBI get the regulatory aspect? but the government was very sure that SEBI is the right authority, because ultimately when you see the primary three objectives of Securities Exchange Board of India, it says that it is for the purpose of protecting the interest of investors. So here also interest of investors has to be protected. They are going to contribute their money for returning returns, whether or not it is for the purpose of investing in the shares or securities or for some other objective. So the government was sure that this particular scheme or these kind of schemes had to be put under the regulatory ambit of the Securities Exchange Board of India. But because as per the SEBI Act of 1992 did not give powers to SEBI to deal with such cases or such kind of schemes, we had to first make an amendment to the SEBI Act of 1992, and then we had to create the CIS Regulations of 1999. Foundation. A press release was issued in 1997 conveying that all the schemes which do not come under regulatory authority of any of the regulatory body is going to be called as a collective investment scheme. So till now, these kind of schemes did not have a name. You did not have a legal name to address these kind of schemes, and that is when they said that any scheme, whatever it may be, whatever is the objective of the investment, whatever is the purpose of investment, if you are going to collect a money from a group of people for some objective, that is going to be called as a collective investment scheme, and it is going to be regulated by the Securities Exchange Board of India. This was announced by the government in the year 1997. Now, in order to regulate the collective investment scheme from the point of view of the investor protection as well as promoting legitimate investment activity, SEBI was asked to formulate the draft regulations, that is the CIS regulation, what we call as the collective investment scheme regulation. Once the government made the press release and announcement that all these schemes are going to be called as a collective investment scheme, they gave the work to SEBI saying that we are giving you so much time, you have to submit us the draft regulations for regulating the collective investment scheme from two purposes. One is from the point of view of protecting the investors' money, that they should not lose their money to fraudulent activities, scams or wrongful promoters. And second one is legality of investment. What is the objective of making that investment? That money that you're going to give to the company, to the launchers of that particular scheme, whether that is going to be used for a legal purpose or an illegal purpose, that also had to be seen. So for these two objectives, they gave the work, they gave the task to the Securities Exchange Board of India to draft the CIS regulations. The press release that they said that it further stated that once these regulations come into force, it is expected that they will promote a legitimate investment activity in the plantation and other agricultural based business, while at the same time giving investors proper protection of their investment. Same thing what we studied in the previous slide. It was dual. Two motives, two objectives were there from bringing into existence the CIS regulations. What are the two objectives? First objective is that we want to give protection to the investors. Whatever money we are going to give, we have to protect the investment that is being made. And second objective is there should be the legitimate investment. The objective for which we are going to make an investment, that should be legal, it should be legitimate. So to ensure these two things, we have to bring into existence the CIS regulations, and the work of drafting the CIS regulation is vested with the Securities Exchange Board of India. For that purpose, to draft the regulation, you need somebody to work on the draft, and that is why the SEBI has created a committee under the chairmanship of Dr. S.A. Dave for the purpose of examining and finalizing the draft regulation for the collective investment scheme. So they have given the work to SEBI. So SEBI has to appoint some people who are going to work on that particular activity. So it has created one committee which is exclusively going to work only on the collective investment scheme draft, how we should regulate it, what are the aspects we should keep in mind, and that is why Dr. S.A. Dave, he was appointed as the chairperson for the purpose of creating these draft regulations. And the committee apart from working by itself and doing a lot of research, analyzing the statistics of all the existing schemes which were running in the market, what were fraudulent, what were genuine, after reading all the statistics, apart from that, they also called for representations from various other government ministries, regulatory bodies, consumer forums, professional bodies and plantation industries to analyze the actual practical scenario. They wanted to go into the depth of every detail, and that is why they did not merely rely on their research, but they also called upon other people who might have any idea about such activities, such kind of schemes, to get more details about it. Apart from this, they also conducted the field visit. They went to these plantation sites wherever these kind of schemes were launched. They practically have gone to those places, analyzed, spoken to the people, and then created the draft regulations. The committee held its first meeting and began its task by reviewing the information submitted already of existing schemes and structure of the offerings by some of the large collective investment schemes. So they had a lot of data available about the existing schemes, what is going right, what is going wrong. Based on that, they are reviewing and analyzing the information that they have got. That is what they did in the first meeting. Apart from this, they also conducted a lot of site visits to these plantations to analyze the on-ground situation of these schemes. After all these detailed investigations, etc., they submitted a report. Okay, in that report, they have given their guidelines, how it should be there, what should be the draft, basic things they have provided. As per the data available, it was noticed that large sum of money had been collected by entities which did not have sufficient experience in agro-based activities. First thing that they noticed was a lot of people are collecting the money in the name of crop activities, in the name of plantation, in the name of growing commercial crops. But as such, they had no idea, they had no agricultural background, they did not know how the crop functions or what are the things that you should keep in mind. They had absolutely no knowledge about agriculture or plantation, but they had raised money for this particular objective. The schemes were typically, so the first problem is whatever was the objective for which the money is raised, people did not have experience on that particular subject matter. Second thing that they noticed that was a wrongful intention was all the schemes are open-ended. That means it never had a maturity date. It did not have a maturity date. It is open-ended. Okay, and disclosures made to the investors was not adequate to enable them make an informed decision. Whenever you see SEBI, whenever we are going to raise money from public at large, whether it's through the IPO, FPO, any kind of issue that we are going to make to the public at large, we have to give them an offer document in which we should give every detail which is required so that the investors can make an informed investment decision. Whatever data is required to properly analyze and make whether this investment is safe for me, whether it is not safe for me. To come to that conclusion, you need information. That information is provided in the offer document. That is what SEBI mandates. In the offer document, certain information should be there, and we ensure that you provide that information to the investor so that they can make an informed investment decision. But under these schemes, because there was no regulatory authority, the information that was given to the investors when they were promising high rate of returns was not enough, because of which they were not able to make a good investment decision. They were not able to make an informed decision. These are the three drawbacks they found out, that people did not have experience for the objective for which they were raising money. The schemes were open-ended, it did not have a maturity period, and thirdly, that the information that was given while raising the funds was not enough. On the basis of the information that is provided, a person cannot make a good investment decision. So these are the three things that they identified out of all the research and details that they were conducting. Then the other risk that they thought was, three we have discussed. Fourth one is that there is high risk associated with the long gestation period involved, coupled with the crop risk. Now, this particular fourth kind of risk is associated with the objective itself. When I told you agricultural plantation, it takes many years to cultivate, to ultimately serve it and use it as a commercial product. It takes a longer period of time. So, the gestation period is wrong. Plus, there is also risk of crop, means the crop might be infected by some kind of insects, worm, okay, it is damaged. Some natural calamities like earthquake, flood, drought, these things might damage the crop. Some wild animals might damage your crop. Anything might happen to the crop. So if once the crop is destroyed, entire money that you have invested is gone. It is going to be an ultimate loss. So these are the additional risks that are associated with plantation activities. That is why the committee members felt that some interim measures for investors protection must be notified pending finalization of the regulations. So before ultimately finalizing the CIS regulations, these are the factors that we have to pay extra attention to. The committee also made certain recommendations saying that whenever anybody is going to launch a scheme that is going to be called as a collective investment scheme, they have to ensure that they get it assessed from a proper independent accredited agency. They should get credit rating, they should get a score for the validity of the score. What is the chance, okay, what is the capability of the person to return back your money along with investments. You should get the appropriate gradings for your investment or the scheme that you're going to create. So this was the recommendation that was given by the Dave committee. Now, CIS regulations were being drafted by SEBI and they launched the SEBI CIS Regulations 1999 after all the committee reports, the disclosures, requirements, etc. So, in 1997 to 1999, so many years they have taken to draft these CIS regulations, which we are going to focus on in today's session. Now, what is a collective investment scheme? In basic terminologies, I have told you that where a lot of people are going to put their money in the hope of getting high rate of returns for a common objective. Okay, that is going to be called as a collective investment scheme. Now, let us see what is the actual definition of a CIS. A collective investment scheme is a scheme that comprises a pool of assets that is managed by a collective investment scheme manager, and it is governed by the regulations given by the Securities Exchange Board of India. So they are saying that there is a pool of asset, they are saying that there is one manager to manage the money that is being collected, and all this is going to be regulated by the Securities Exchange Board of India. So out of this you can derive 3 points. First point is that there is going to be some kind of asset. To manage this asset you need a manager, which is going to be called as a collective investment management company, okay, generally. And to manage the assets and to ensure that the manager is doing his job correctly, we need certain kind of regulations, and these regulations are going to be provided to us by SEBI. That is nothing but the SEBI CIS Regulations of 1999. This is the definition of collective investment scheme. Now let us see. Like I told you, SEBI did not have the power to address any random schemes. So to put such random schemes under the ambit of SEBI, we had to make an amendment to the SEBI Act of 1992, and that is when section 11AA was amended, and we gave power to the Securities Exchange Board of India to regulate all pooling of funds. We did not only focus on pooling of funds by listed companies. Now SEBI also has been given the power to pool all funds from the public at large under the name of any scheme. You call it a plantation scheme, commercial crop scheme, a holiday planning scheme, okay, anything, whatever may be the objective. We are not concerned with the objective. We are concerned with the money of the public at large, where all the people are contributing money in some kind of scheme. Any scheme, whatever name you keep, whatever objective you keep, we are not worried about that. If you are pooling money from the public at large in the name of any scheme or arrangement in excess of 100 crore rupees, which is not regulated by any other law, thus slipping into the ambit of collective investment scheme. So it is going to be called as CIS, and the power has been given to the Securities Exchange Board of India, that now you are not only concerned with the money that you're going to raise by listed companies, but any person who is going to raise money from the public at large in the name of any scheme, any arrangement, or any kind of activity, you are responsible for the money of the public at large. Whatever be the name of the scheme, it is going to come under the ambit of collective investment scheme. And now power has been vested on SEBI to regulate these activities. Only by the virtue of amendment to SEBI Act, SEBI has been able to pass the SEBI CIS Regulations of 1999. Let's directly, this was the historical background of why there was a need to regulate these schemes and how SEBI as a regulatory authority has got the power to control and regulate these kind of schemes. So let's just begin with the scheme. First, you should understand what are the kinds of collective investment scheme. One is the regular collective investment schemes, which come under the ambit of the CIS regulations. Directly in the definition of CIS, it is going to commence it. What does that say? CIS means any scheme on any arrangement which satisfies the condition provided under section 11AA. We know that under SEBI Act, we have given power to SEBI to monitor some kind of activities, to regulate certain kind of schemes. For that also certain conditions have been laid down under section 11AA. So if you're satisfying those conditions, you are called as a collective investment scheme. Now there are other kind of schemes which do not satisfy. They do not satisfy the conditions laid down under section 11AA. Plus, there's also section 11A subclause 3 which says that what are not collective investment schemes. So you do not come under the ambit of what is CIS. You do not come under the ambit of what is not CIS. You are something else which does not come under the ambit of these two activities, but you are raising money from the public at large amounting to 100 crore rupees or more, then automatically you will be deemed to be a CIS. You are going to be deemed to be CIS. You are not a collective investment scheme as per the definition that is being provided. You are not satisfying the conditions to be called as a collective investment scheme. But we are treating you as a collective investment scheme because the amount that you have collected from the public at large is 100 crore rupees or more, which is a huge sum of money. So what does this mean? There are two kinds of CIS. One is the regular CIS which satisfy all the conditions, and by virtue of law itself, it has to be treated as a CIS. But there are other kind of schemes which do not satisfy the condition of being called as a collective investment scheme. As such, it is not a collective investment scheme, but the amount that they are collecting from the public is more than 100 crore rupees, because of which we are going to treat you. You are not a CIS. It is actually not a CIS, but is being treated as a CIS. By the virtue of law, it does not satisfy the conditions of being called as a collective investment scheme. But because of the amount being involved, that is 100 crore rupees or more, which is huge, we want to treat you as a collective investment scheme. So one is regular CIS, which comes under the definition legal ambit of the CIS regulations. In the CIS regulations, under the SEBI Act itself, we have laid down the conditions. You're satisfying those conditions, that is why you're going to be called as a collective investment scheme. Second one is, you do not satisfy the conditions, you're not a collective investment scheme, but you're collecting 100 crore rupees or more from the public at large. That is why we are treating you as a collective investment scheme. So these are the two, if you see, these are the two kind of schemes. Now, I told you section 11A is very primary for analyzing, because which section 11A of SEBI Act of 1992. SEBI Act of 1992, this particular enactment, section 11AA, gives us the primary definition what is a collective investment scheme. The first aspect, this one, no, this comes under section 11AA. Okay, so first we are going to see what is a collective investment scheme. So according to 11AA, we have 4 subsections. First subsection talks about enabling provision. It gives the definition for what is a collective investment scheme. Clause 2, subsection 2, subsection 2A gives down the conditions for being identified as whether it is a collective investment scheme or not. And last, subsection 3 talks about what is not considered as a collective investment scheme. So 11AA itself gives you the definition of CIS. It lays down the conditions for being eligible to call as a CIS, and also certain list of activities which shall not be considered as a CIS. Okay, this is what we are going to study. First, let's see subsection 1, which gives you the definition for a collective investment scheme. It says that CIS is any scheme or any arrangement which satisfies the conditions laid down under subsection 2 and subsection 2A, and it is going to be called as a collective investment scheme. So according to the law, they say that collective investment scheme is any scheme which fulfills the condition laid down under subsection 2 and subsection 2A. So now if we want to identify whether a particular scheme is a collective investment scheme or not, we should see whether the conditions given under or eligibility criteria given under section 2 and 2A are satisfied or not. So let's see what is subsection 2. Subsection 2 lays down 4 eligibility criteria. 4 criteria are provided. If you satisfy these criteria, that means you are going to be a collective investment scheme and you will be regulated under the CIS regulations of 1999. So first one, any scheme or arrangement made or offered by any person under which first one, a contribution is going to be received or payment is going to be made by the investor in whatever name you call it subscription money, unit money, okay, whatever, any name you say, you can give it any money. You can call it as any money, okay, it is any money that is going to be paid by the investors, which is going to be pooled and utilized. It is going to be pooled means there are going to be many contributors. A lot of investors are going to give their money, which is going to be created as a pool of investment, and that money that is collected is ultimately utilized for a specific purpose that has been specified according to the scheme details. So what is the criteria? There should be some money that is going to be given by the investors. That money is some kind of consideration for investment. That money is pooled in from a lot of investors, and that money that has been pooled in is going to be utilized for the purpose as maybe has specified for that particular scheme. Whether it is for growing crops, whether it is for taking a holiday package, whatever may be the activity. If you are taking for that, if this first point is satisfied, you are moving ahead to be called as a collective investment scheme. Second point is, whatever money we have received in the first step from the investors, using that money, using the contribution, using the payments received from the investors, we are going to invest in some kind of, we are going to make that investment to receive profits, income, produce, or any kind of property, whether movable or immovable, from such scheme or arrangement. We are going to, the person who is going to launch that particular scheme is going to take that subscription money, contribution or payment from the investors, ultimately with the objective of making some kind of profit, making some kind of income, buying some kind of property, movable, immovable, whatever may be the reason, whatever may be the objective, the money that is being received should be used for generating further sum of money or some kind of property, income, returns, okay, profit, any kind of property. So money that is collected in the first step should be utilized for earning some kind of returns, income, etc. in the second step. Third one is, all the money that is being collected, all the properties that you have bought in the second step, all the income or all the returns that you have earned through that money, everything is going to be managed by a third party. The investors have no control over the money once they have given. Now, if you see a company form of organization, shareholders are the ultimate decision makers. If the company wants to make any decision, it has to pass a shareholders resolution. You have to take the consent of the shareholders. Somewhere they are also part of decision making of a company. But under the collective investment scheme, these investors have no role to play. All the decisions are going to be taken on behalf of them. A third party is going to manage all the funds, manage the property, or manage the entire scheme itself. They have no control over any money that once they have given it to that particular scheme. Lastly, the investors do not have a day-to-day control over the management and operations of these kind of schemes. So ultimately, if you want to be classified as a collective investment scheme, very, very important point. This is one of the questions where again and again they ask, they want you to analyze whether a given scenario, a given scheme falls under the ambit of CIS or not. So if you want to identify whether a scheme is CIS or not, you should know these 4 points. First one, a quick recap of what we have discussed. First one is there should be some kind of consideration or payment. Who is going to pay this consideration or payment? It is the investors who are going to make it. And the money the investors are going to do, it is for 2 reasons. One is pool, that means there should be more investors. A pool of funds should be created, and that pool of funds should be utilized for a specific reason as may be provided. This is the first step. Second point to be classified as a CIS is the money that you have raised from the first thing is used to generate some kind of income, some kind of profit, some kind of property, whether movable, immovable. So that money is going to be used for some specific purpose, for the purpose of generating income, profit, or buying some kind of property. Third point is, whatever money is there, whatever building property is there, anything associated with the scheme is going to be managed by a third party. That means the investors have no role to play. Investors have no role to play. On behalf of someone, on behalf of the investor, somebody else is going to manage what we called as the collective investment scheme property. The property of the collective investment scheme is going to be managed by a third person. Investors have no control over the money or the property of the scheme once they've made the investment. And lastly, over the day-to-day activities, the day-to-day control, the investors have no role to play. They have no role to play in the day-to-day operation and management of the scheme. If these 4 points are satisfied, we call that particular scheme as a collective investment scheme. So these conditions are given under section 11AA subsection 2. Subsection 1 says that a collective investment scheme is a scheme which satisfies the condition given under subsection 2 and subsection 2A. We have already seen what are the conditions given under subsection 2. Now let us identify what are the conditions given under subsection 2A. Here they have not given us any conditions. They have said that if at any point in time the CIS regulations, we have given the power to SEBI to identify what is CIS, to regulate the CIS, collective investment schemes. So if SEBI is going to impose any conditions under the CIS regulations, they should satisfy those conditions. Now we are seeing section 11AA. It is not SEBI which has drafted this. It is the legislature. In the parliament, we have drafted this particular enactment, SEBI Act. But further delegatory provisions we have given to SEBI. SEBI has further power to make any laws for regulating CIS. So we have given 4 conditions to be identifying whether a particular scheme is a collective investment scheme or not. After this, we are leaving it to the SEBI, Secretaries Exchange Board of India. Further, if any conditions are going to be added by SEBI under the CIS regulations, those should also be satisfied to be called as a collective investment scheme. That is what subsection 2A says. It says that any scheme or arrangement made or offered by any person satisfying the conditions as may be specified in accordance with the CIS regulations is going to be there. So first set of 4 categories for calling a CIS that has been given under the SEBI Act itself. In addition to this, if SEBI is going to specify any more conditions under the CIS regulations, even those have to be satisfied to be called as a collective investment scheme. As of now, we have 4 criteria given under subsection 2. Next, subsection 3 there are certain kind of activities which are not treated as a collective investment scheme, which cannot be considered as CIS. Even if you're going to, even if the 4 criteria satisfied, we saw the 4 criteria, right? Collecting the money from public at large, utilizing it for some specific purpose, and it is going to be utilized for the purpose of generating income, profit, return, buying some kind of property where people have no control over that property, scheme property. All these conditions, if you are going to satisfy, it is going to be called as a collective investment scheme. Now, there are certain kind of schemes which satisfy all the given points, which satisfy these 4 points, but still they cannot be called as a collective investment scheme merely because they are regulated under some kind of law. What was the purpose of bringing in the CIS regulation? Because it was not regulated by any regulatory authority, we thought SEBI has to become the regulator. But now, if you're only giving these 4 points, that means all other existing schemes will also be called as a collective investment scheme, but they already have a regulatory authority. So that is why they have clear-cut made a distinction that if there is some kind of scheme which is satisfying these 4 criteria given under section 11AA subsection 2, but already one regulatory authority is there to control that kind of scheme, we are going to keep those kind of schemes outside the ambit of CIS regulations. So what do they mean? What are we going to study under subsection 3? That kind of scheme is satisfying the 4 criteria to be called as a CIS, but it already has a regulatory authority for it, and that is why it is not going to come under the ambit of CIS. Now, what are those kind of activities? There are in total 9 categories of schemes, 9 categories of activities which are not considered as a collective investment scheme. The first one is a cooperative society. In cooperative society also we receive membership fees from the public at large. Whoever want to become the member of that society, they have to pay the membership fees, right? So if you are a cooperative society, you are registered under the Cooperative Societies Act of 1912 or any society registered under the Societies Act, then you are not going to be called as a collective investment scheme. Second one, if you are a non-banking financial company and you are registered and regulated by the Reserve Bank of India, you will not be called as a collective investment scheme. If it is a contract of insurance where you are collecting the premium money from the public at large on a promise that you are going to insure their products or any kind of activity. If it is a contract of insurance, in that particular case, it is regulated under the Insurance Act of 1938 where IRDA will be the regulatory authority. In that cases, these kind of schemes or insurance contracts will not come under the ambit of a CIS. Any deposits which are accepted by the non-banking company coming under the ambit of RBI. Any deposits given by the Nidhi companies, accepted by Nidhi companies under Companies Act. Any deposits declared by the company as a Nidhi, like I told you, under the Companies Act. Any chit fund established under the Chit Funds Act. Any contribution made in the nature of a mutual fund, because you have the mutual fund regulations of SEBI itself as a regulatory authority. So you have a specific regulation for mutual funds, so it is outside the ambit of CIS regulations. Or any other scheme which can be notified by the central government after consultation with SEBI will not be considered as a CIF. So total 8 specific points are there. One point is the general point where they are keeping the scope open that any point in time, if new point has to be added, that power has been vested with the central government. From time to time, if you want to increase the number of activities which should not be considered as CIS, that it is an open list. At any point in time later, you can add some points to the existing list. So if you see all these transactions, all the activities, they satisfy the 4 criteria, but they are outside the ambit of CIS merely because they already have a regulatory authority, whether it is the Companies Act, that is ROC, whether it is SEBI, whether it is RBI, whether it is the Cooperative Society Registrar. Some regulatory authority is already there to monitor these kind of schemes, to monitor these kind of activities. That is why it need not be brought under the CIS regulations. So quick recap, these 9 points are going to determine what is not considered as a CIS. a cooperative society, non-banking financial company, contract of insurance, pension provident fund for insurance scheme for employees under EPF Act, deposit under Companies Act, deposit by Nidhi companies, chit fund, mutual fund, or any scheme notified by the central government after consulting with SEBI. So all these kind of activities, even if they satisfy the 4 points, 4 criteria under section 11AA subsection 2, even then they are not considered as CIS merely because they already have a regulator for them. They already have a law in place for regulating their activities. That is why these 9 points are not considered as a CIS. Okay, so we know what is CIS. If you satisfy 4 given points, you're going to be called as a collective investment scheme. We know what is not CIS, 9 points, which though they are satisfying the 4 given criteria, but they already have an existing regulatory authority, they cannot be called as a collective investment scheme. And one more concept we saw, deemed collective investment scheme, even if they are not satisfying the given points, but the amount of money that they are collecting is 100 crore rupees or more, in that case, they are going to be called as a collective investment scheme. So does that mean that every CIS should have a value of 100 crore rupees or more? The answer is no. A collective investment scheme can have a value less than 100 crore rupees. That is going to be coming under the regular collective investment scheme. But if you are not a collective investment scheme but raising 100 crore rupees or more, only then it is going to be deemed to be a collective investment scheme. Now, next important aspect that we have to study is the collective investment management company. Like I told you, where there were a lot of friends, one of the friends had taken the responsibility of managing the money, but he went off. He took the money and flew away. So like that, you need somebody to monitor the money, to monitor the property. The person who is going to launch the scheme, the person who is going to conceive the idea of having that particular scheme, okay, that is going to be called as the collective investment management company. And for that, definition has been given that it has to be a company form of organization which should be registered under the Companies Act, whether the Companies Act of 2013 or any previous law. So you should be registered as a company form of business organization under the provision of Companies Act. And in addition to that, you should have obtained the registration from Securities Exchange Board of India under the CIS regulations, whose objective is to organize, to operate, or to manage a collective investment scheme. So even if one of these activities are being undertaken, whether you're launching it, operating and managing, whether you're doing any one of these activities or all of these activities in relation to a collective investment scheme, you are going to be called as a collective investment management company. So it should be a company form of organization, and the objective of that company form of organization is to operate, manage and organize a collective investment scheme. So if you're this kind of company with this particular objective, you're going to be termed as a collective investment management company, and this particular company has a lot of obligations under this particular regulation, because they have to monitor the entire property of the collective investment scheme. Now, close-ended collective investment scheme. What does this mean? When we were studying the drawbacks, we identified that most of the schemes that were existing at that point in time before the CIS regulations came into place were close-ended schemes, means they did not have a maturity period. But once the regulations were brought into force, SEBI has clearly laid down that any collective investment scheme can only be close-ended. That means it should have a fixed maturity period. It should have a fixed maturity period. That means open-ended schemes are completely prohibited. Any collective investment scheme cannot be open-ended. It has to be close-ended. That means it should have a fixed maturity period. That means to say that when you're going to collect the money from the public at large, you should specify to them what is the duration. Your investment is for 10 years, 5 years, 20 years. When are you going to get back the returns? That period should be fixed and it should be specified right at the beginning. So that is a close-ended collective investment scheme. Any collective investment scheme which is launched by a collective investment management company where there is a fixed period of maturity and there is no provision for repurchase before the expiry of that maturity. That means again and again we are not going to open the scheme. Once you have collected the money in the name of some scheme, you cannot multiple times open and collect it for the same reason. Right? So you cannot also have an option of repurchasing before the expiry of the maturity period. Only after 20 years period is over, further 20 years you can collect the money, but only after the maturity period is over you can allow the repurchase of the same kind of asset, same kind of units of that particular scheme. So what is a close-ended scheme? That it should have a fixed maturity period. The duration of investment should be specified, and at the end of the duration you should be able to pay them back the principal amount along with the returns that they have earned over that particular investment. Please keep in mind a high note you should make, that collective investment scheme cannot be open-ended. It is not permitted to have an open-ended collective investment scheme, that is a scheme with no maturity period. That is completely prohibited under the CIS regulations. Next, coming to what is a collective investment scheme property. Investment scheme property. Once you have launched a scheme, you have created a scheme, in that a lot of money is going to be involved. Okay, so what all is going to be called as a property? First and foremost is any money that is given by the investors. Primarily we are going to make some kind of payment of consideration, no? The investment that we are going to make, the principal investment that we are going to make, that money, monetary value, rupees, that is going to be property of the scheme. Second one, using the money that we have collected, if we are going to buy some kind of property, that property will not become the property of the launcher of the scheme. It is the property of the scheme. It is the property of every unit holder. It is the property of every investor. It cannot be the property of the person who has launched the scheme, because you have utilized the money given by the investors. The property which has been bought by using the money of the investors, all such properties are going to be treated as the properties of the collective investment scheme. Thirdly, when you have the money, if you have not bought a property, you have kept it in some kind of bank. You have made an investment somewhere. Okay, this money is further going to generate some kind of income. Or this property, you have bought a property, that property you have given on rent, that property you are generating some kind of rental income, some kind of lease income. So any income that you are deriving out of the property, out of the money or property, further you have any kind of income, that income is also going to become the income of the collective investment scheme itself. So first one is the money that the investor are going to give. Second is, out of the money that the investors are giving, if you are going to buy some kind of property, that property is also the property of the scheme. Third one is the money, when you are keeping it bank, you are going to earn some interest. The property, if you are going to sublet it, you are going to send it or rent, you are going to earn the rental income. Even the rental income is going to become the property of the collective investment scheme. So 3 points are there: the money, the property, and the income from the money and the property. All these things collectively is going to be called as the collective investment scheme property. And it has to be managed by the collective investment management company. Next, there is a concept of unit and unit holder. Like a share and share capital shareholders, same concept is going to apply here. You have a lump sum value that you have collected. This is the pool of money that we have collected. Out of this pool of money, depending upon how much money you have contributed, you are going to have a percentage of holding in that scheme property. That is nothing but the unit. How many units, what is your share of money in this particular entire pool of money? That is the unit that you are going to hold. And any person who has a percentage of holding in the scheme property is going to be called as the unit holder. Let's see the definition. Unit means any instrument issued under a CIS by whatever name you call, denoting the value of subscription of the unit holder. So what is your percentage of holding? What is the money that you have contributed to this pool of money? Because you have given us the money, we are going to issue you some kind of document. When we invest in the share, we get a share certificate in our name. That is the document proving your investment in the company. Similarly, when any investor is going to give any kind of money to the collective investment scheme, they are going to give you units not share certificate. We are going to get units in this particular scheme. And every person, a unit holder means any person who has a unit in a collective investment scheme. If you have any percentage of holding in the scheme property in the collective investment scheme, you are going to be called as the unit holder for the contribution that you have made. Next, who can launch a collective investment scheme? So it is only and only, so now we are going to see and learn how to read law. I have given exact copy paste of what has been provided under the regulation. Then we are going to simplify this and understand the scenario. No person other than a collective investments management company which has already obtained a certificate under these regulations, means the CIS regulations, shall carry on or sponsor or launch a collective investment scheme. So by reading this particular paragraph, you are able to answer two questions. Who can launch a collective investment scheme? It is the collective investment management company which has the permission to launch a particular scheme. For that, they have to satisfy one eligibility criteria, and that eligibility criteria is that they should be already having a certificate of registration issued by the Securities Exchange Board of India under the CIS regulations. So if a collective investment management company is planning to launch any collective investment scheme, it has to first get a certificate of registration from the Securities Exchange Board of India. Only then it can launch a collective investment scheme. Next, we know that if your collective investment management company wants to launch a collective investment scheme, it has to get a certificate of registration from SEBI. How do we get that certificate of registration? By making an application. Okay, so no person shall sponsor or cause to sponsor or carry on any venture capital fund, collective investment scheme, including mutual fund, until unless he obtains a certificate of registration from SEBI in accordance with these regulations. So section 12 is the foundation which directs that registration is mandatory. We will see how to make an application. But what provision of law makes it mandatory for the collective investment management company to obtain a registration? It is section 12, where clearly they say that if you don't have a certificate of registration, you cannot launch or collect any kind of money. Okay. This section has been added by the way of an amendment, and that is why, what is the impact of this particular amendment? A clear-cut ban has been imposed on any person carrying on any collective investment scheme without obtaining a SEBI registration, because CIS was a newer concept. We have added the concept of CIS, given the power to SEBI to regulate CIS by the way of an amendment. So here also in the registration provisions, we have clear-cut said that if you don't have a valid certificate of registration from the Securities Exchange Board of India, you cannot carry on or launch a collective investment scheme. So clear-cut ban has been imposed on any person who is currently running a collective investment scheme without obtaining the certificate of registration from the Securities Exchange Board of India. Next, coming to the registration procedure, we all know that if anybody wants to launch a collective investment scheme, they have to obtain a collective investment scheme registration. That as a collective investment management company, you have to obtain a certificate of registration from the Securities Exchange Board of India. Now, this entire application process of registration has been classified into three parts. First part is to the newer activities. You are till now, you have not launched any scheme. You are not a collective investment management company. After the CIS regulations, have come into force, after that you are planning to start a collective investment scheme, then you are going to come under the ambit of first procedural requirement. Next is, if you are a deemed collective investment scheme. Okay, we have already seen what is a deemed collective investment scheme. For that, there is the second procedure. And third one is application for registration of an existing collective investment scheme. What is existing collective investment scheme? Before the CIS regulation came into picture, you have already started some kind of scheme which fulfills the criteria given under the section 11A subsection 2, you can be called as a CIS, but that point in time there were no regulations, so you just started the scheme without any registration. But today registration is there, today law is there, today regulatory aspects are there, so you have to comply with it. One is for the newer activities. Today you want to start it, obtain the registration. Deemed CIS, you are not a CIS, but you are satisfying some kind of condition, that is a pool of money of 100 crore rupees or more, you have to obtain the registration. And third criteria, you're already operating a scheme, you're already running a scheme, but at that point in time no law was there, but today's law is there, so you also have to make an application for registration. So we are going to see the application or registration process for all the three kind of scenarios. First one, let us consider the grant of application for grant of certificate for a newer scheme. So any person who is proposing to carry on any activity as a collective investment management company on or after the commencement of a CIS regulation, like I told you, this is for the new schemes, new collective investment management company. You're going to plan a scheme, and you're getting this idea only after the CIS regulations of 1999 have been passed. After the regulations have come into picture, if you're going to plan a scheme, then you have to obtain your certificate of registration under regulation 4. You have to apply, you have to make an application to Securities Exchange Board of India for getting a certificate of registration. So what does this regulation say? Regulation says that if you want to become a collective investment management company, after the CIS regulations have come into force, still you have to make an application to SEBI for obtaining the certificate of registration. Next one is deemed CIS. Deemed to be CIS, even they have to obtain the certificate of registration. They say that any person who is proposing to carry on or launch any scheme which is going to be coming under the category of deemed to be CIS, that means they are not satisfying the 4 eligibility criteria, but the pool of money is 100 crore rupees or more. That is why they are called a deemed CIS. They are going to be treated as a CIS, and because they are treated as a CIS, they also have to obtain a certificate of registration from SEBI. That is why they have to make an application to SEBI for obtaining the certificate of registration. Any scheme or arrangement which is otherwise regulated or prohibited under any other law is not a collective investment scheme. So the 9 points we have already seen what is not considered as a collective investment scheme. Those kind of schemes need not obtain any kind of registration by SEBI under these regulations. They need not make an application under CIS regulations to obtain any kind of registration, because they are already regulated under some other kind of law. So CIS regulations, the guidelines and the circulars, everything is applicable to a deemed CIS. Okay, we are going to treat a deemed CIS as a CIS. So whatever law is applicable to a regular collective investment scheme, same law, same guidelines, same notification, same circulars will also apply to a deemed collective investment scheme. Next. In case of existing CIS, that means before the coming of the CIS regulations of 1999, you already have a scheme. The scheme is already operating. You're running the scheme from 5 years. Today, you have to obtain the certificate of registration because today law has come into force. So what it means, say, any person who immediately prior to the commencement of the regulation is already operating a collective investment scheme, they have to make an application to the Securities Exchange Board of India within the period of 2 months from the date when the law comes into force. We are giving you 2 months time to get yourself registered with the Securities Exchange Board of India. But if you see the actual scenario, this was extended timeline was given to the existing collective investment schemes to get themselves registered. So if you are a scheme which is operating before the CIS regulations came into place, you have to today make an application within 2 months to get yourself registered as a collective investment management company. This is applicable to both the CIS and deemed to be CIS. You're an existing CIS or you're an existing deemed CIS. Both of the existing thing have to obtain the certificate of registration under these regulations. Next is Application by existing CIS, like I told you, existing CIS also have to make an application for getting the certificate of registration. But then there are multiple scenarios that are possible. What are the actions that can be taken by SEBI? SEBI is going to get an application that we are an already existing collective investment scheme. We are making an application to get the approval. In that scenario, SEBI has three solutions to the application. First one is they are going to grant you provisional registration. What is provisional registration? That we are ready to give you registration provided you satisfy certain conditions. We have no problem in giving you the registration, but there are certain things that are missing. You have to fulfill those things, then we are going to give you permanent registration. So this is nothing but temporary registration. Temporary or provisional registration. We are giving you registration subjected to fulfillment of certain conditions. Once you fulfill these conditions, we are going to give you the permanent registration or the final registration. That can be the first response by SEBI. You're going to get an application, SEBI is going to get an application from the existing CIS. So it is going to say, okay, this everything is there, certain things are missing, so we are ready to give you the certificate. There is no ground for rejecting the application, but there are certain things that you should fulfill. So we are going to give you a temporary registration. Once you fulfill the conditions that we have given, we are going to issue you the final certificate of registration. That is the first option. Second option is grant the final certificate. Everything is proper. Everything is accurate. We are directly going to give you the certificate of registration. Third one is directly reject the application. Whether the people are not proper, objective is illegal, or the way it is operated is not proper, it is not in the interest of investors. For all these reasons, directly we are going to reject the application. So we are going to give you temporary registration subject to fulfillment of conditions, or we are going to give permanent registration, that is the final grant of certificate, or we are going to reject the application. These are the three possible scenarios when an existing CIS is making an application to SEBI for obtaining the certificate of registration. Next, when an existing collective investment scheme has to close its operation, has to shut down its business, has to close the scheme, has to wind up the scheme in three given scenarios. First one is where we have given you 2 months time to make an application for getting yourself registered or get the certificate of registration. If within 2 months time or further extended period, if you have not made an application for getting yourself registered as a collective investment scheme, automatically you have to wind up your scheme. Second one is you're not granted provisional registration. That means your application was rejected right at the beginning. When you have made an application for seeking the registration, that time itself we have rejected your application. That means you are not permitted to operate as a collective investment management company. That means you are not permitted to launch a collective investment scheme. That automatically means you have to close, you have to wind up your scheme, return back all the money to the investors and close the scheme. You cannot operate the business as a collective investment scheme merely because you did not get the approval to run a collective investment scheme from the Securities Exchange Board of India. And third one is where the provisional certificate or registration was given to you on the condition that you should fulfill certain criterias. But when you fail to fulfill the conditions that are imposed through the provisional registration, then also you have to wind up the scheme. So the scheme for the existing collective investment companies can be wound up on three grounds. First one is when you have failed to make an application for registration within the given period of time. Second one, the application has been rejected by SEBI. Third one is where provisional certificate was issued subject to the fulfillment of conditions, but you have not fulfilled those conditions. If these three scenarios come into picture, you have to completely close down or wind up the scheme, return back all the money to the investors and close the business of the collective investment scheme. You cannot run a collective investment scheme in these three given scenarios. Next, on the other hand, if you are satisfied all the conditions, okay, whether it is a new application, deemed CIS or the existing CIS, SEBI is happy, okay, SEBI is going to receive the application and it is satisfied that everything is proper, it can go ahead and grant the certificate of registration as may be necessary. Once you have obtained the certificate of registration, you can commence the business of launching your collective investment scheme or continue to operate the existing collective investment scheme. Next, Other scenario is where your registration is not granted, means your application has been rejected, whether it is a new application or the existing CIS. Okay, your application is going to be rejected. In that case, before rejecting, SEBI has to follow certain procedure. First and foremost is an opportunity of being heard should be given. Without hearing the other party, basic principles of natural justice, without hearing the other party, you cannot pass a judgment. You should give him an opportunity of saying why we should not cancel, why should we not reject his application. We should hear him, what is his point of view on our reasoning. Okay, and whenever we are going to make the final decision after being heard, after giving the opportunity of being heard, we are going to make a final decision. The final decision should also be communicated to the applicant within 30 days, along with the decision saying that your application has been accepted or rejected. If you are rejecting the application, you should also specify the reasons. What are the grounds on which we are not giving you the registration? What are the reasons because of which your application has been rejected? The decision and the reason for that particular decision should be communicated within 30 days of making the decision to the applicant. Next is the business activities of CIS. Once you have obtained the certificate of registration to operate as a collective investment management company by getting the registration under the CIS regulations, then you can start launching your collective investment scheme. But once you are registered as a collective investment management company, there are certain kind of restrictions that have been imposed. There are certain kind of restrictions on the activities that can be conducted by the collective investment management company. 4 primary restrictions are there. A collective investment management company should not engage in any activity other than managing a collective investment scheme. That means no multitasking. If you are a collective investment management company, you should only focus on the collective investment scheme. You should not multitask. You should not have n number of other businesses. You should have only one objective, collective investment scheme. Your entire focus should be on collective investment scheme. You cannot carry on any other business. A collective investment management company cannot act as a trustee of any other collective investment scheme. Now, whenever we are operating a scheme where we are going to collect money from a lot of people, one person is going to be appointed as a monitor of that money to ensure that the money is utilized properly or not, to also ensure whether the manager is doing his duty properly or not. We call that person as a trustee. He's taking the responsibility of all the investors and ensuring that the interests of the investors are protected. So the trustee, any collective investment management company cannot act as a trustee of any other collective investment scheme, cannot launch a scheme for investing in securities, because then it will become a mutual fund. If you're taking the money from a lot of people and investing it in the securities market, it is going to be categorized as a mutual fund. So if you're going to take the money with an objective of investment plan, plantation cropping activities, or commercial crops, or holiday plans, all this is fine. The objective should be other than stock market, other than the securities market. Objective of investment should be anything other than the securities market. If you are investing in the securities market, in that case, it is going to be classified as a mutual fund predominantly. So that is why any money that is collected, pool of money created for the purpose of investing other than in securities, is going to be called as a CIS. So a CIS cannot make an investment in securities. Last one, a collective investment management company cannot invest its money in the scheme that is floated by itself. I have launched a scheme. I cannot contribute to that particular scheme itself. I cannot make an investment in my own scheme. That is not permitted. But in that case, they have given an exceptional situation where they say it is an exception. They say that a collective investment management company can invest in its own scheme, provided it is going to make a disclosure in the offer document when it is going to launch the scheme, and it should not charge any fees for such investment by the collective investment scheme. So 4 restrictions are: first one, if you are operating a CIMS company, you should focus only on the collective investment scheme, you should not have any other business. You cannot act as a trustee to any other collective investment scheme. You cannot make an investment in the securities. It should be for some other reason other than the securities market. And lastly, you cannot invest in your own scheme, but they have provided an exception where you can invest after giving a disclosure in the offer document. But whenever you're going to make an investment in your own scheme, you cannot charge a fee for that. You cannot take a fees from the collective investment management company, cannot charge a fees for investing in its own scheme. So these are the 4 restrictions that have been imposed on the business activities of the collective investment management company. So till now we have seen the operating requirement. We have seen the registration procedure, what is the business, how it operates. In further classes, we are going to see the actual regulatory responsibilities about what are the obligation of the collective investment management company, okay, how it should run, what are the offer documents, what are the details in the offer document, what is the responsibility of the trustee. So all these things we are going to cover in the upcoming classes. Our new batch is going to begin from January 10th. If you are interested, you can get in touch with the number that is provided, 9739733400. And if you want our classes, you can get in touch with us, where we can give you conceptual clarity of each and every concept that you're going to study. With that, let me just wind up the session for today. In other upcoming videos, we are going to complete the CIS regulations. Have a good day.